Yo, it's JP. I'm going to talk today about defending high-stakes misappropriation of trade secret cases. So, if you are not interested in hearing a discussion about defending trade secret litigation, then you should skip this video. It is not for you. But on the off chance that you are interested in hearing a discussion about defending high-stakes trade secret cases, it's your lucky day because I'm going to get right into the mix, okay? By way of background, since starting the firm Pollard PLLC in 2012, I've defended at least 150 cases with allegations about trade secrets or confidential and proprietary information. So this is one of my core wheelhouses. I can absolutely cook in this arena. We have defended some huge trade secret cases. Most recently, we wrapped one up in 2025 where our clients were being sued for $25 million. It was the broader revenue cycle management, healthcare adjacent space. Our clients had left a big company. They were being sued for $25 million. The plaintiff had 3 different expert witnesses, and we were a defense counsel. We were able to resolve that case after the TRO proceedings, the preliminary injunction proceedings, and then discovery and expert discovery. We resolved it in the middle of expert discovery. Basically, we were able to continue operating and making money, right? We got partially enjoined, but we're still able to continue operating and making money in ways that the court permitted us to continue operating. And so that allowed us to continue growing the business, funding the defense. Ultimately, I cooked their damages expert. I took his deposition and absolutely revealed that his $25+ million damage model was a crock of shit, to be candid. And the case settled shortly thereafter. That it's all public. The case is called Mainsail. It's in the Southern District of Florida. It was filed in 24, but it was resolved in 25. And there the plaintiffs were seeking north of $25 million. So we defend a lot of bet the farm cases in the trade secret arena. Now, I'm not going to talk today about the non-compete piece of it, okay? Because the non-compete piece of it, yes, that is often in the mix, but that has to be addressed in its own specific discussion, especially given recent changes to the relevant law, at least in Florida, right? The so-called Choice Act, right? It's the Ken Griffin Citadel Capital. I can't beat JP, so I buy the legislature and get them to pass a law for me. That's what that really is. Hi, Ken. But I'm just going to talk about trade secrets proper, okay? Because you add non-compete to it, and that becomes a much lengthier discussion, okay? So the first rule I'm going to give you in terms of defending these cases is that if you took documents with you, if you stole documents from the prior company where you worked or from a counterparty to a business transaction, right? Whatever the context is. Usually we come at these from the ex-employee standpoint, right? A high-level employee, executive, officer, partner, founder leaves one company and then either goes to a competitor or goes to start his own venture, or multiple people, like 4 or 5 people, a team clears off and then starts their own venture. And we see this in a space, it makes sense, right? We see this in a space where there is a market opportunity. The barriers to entry are relatively low. It's just about having the right knowledge, a bit of hustle, and some sales acumen, right? I see this all the time where these companies making anywhere from, call it 20 million to 100 million in revenue a year, okay? And they're involved in some service capacity, right? You see it in revenue cycle management, you see it in recruiting, okay? But there's no secret sauce. There's no scientific formula. There's no amazing technology. It's literally just like, okay, you got into this niche before the internet blew up, and now like other people know about this shit and it's not a secret, okay? I see it all the time where folks leave a dominant company and start their own competing company because they realize, you know what, there's no reason why I can't do this on my own. And again, it's often in situations where there is no secret sauce. There's no scientific technology, nothing that's like really complex that can't be done by a couple average people who have some hustle to them. So I see it crop up in the employment context, but I've also seen it in the partnership breakup context, and I've seen it in the proposed joint venture context, right? Where one party and another party get together, they're discussing a joint venture, they share some documents and information, it goes south, it does not materialize, and then one sues the other and claims theft of trade secrets, okay? So whatever arena or direction you're coming at this from, I need you to understand, if you stole documents, okay, and don't beat around the fucking bush. If you stole documents, then you need to tell your lawyer immediately, okay? Because I have often told my own clients, if you stole a bunch of documents, okay, that's not dispositive. That's not fatal. I can work with that. I can work with that. I just need to know exactly what the documents are. I'll get into that later, but I literally mean document by document. I need to know exactly what every one of those documents is, what it contains, who created it, what its value is, the list goes on and on. But I will fight these on a document by document basis. So remember, it's not fatal if you stole a bunch of documents. It depends on what those documents are. It depends on what those documents contain. The fatal mistake is to hide that fact, to hide the fact that you took the documents from your attorney, okay? You tell me the truth, you give me all of the facts, all of the details, good, bad, and otherwise, and I will put together our best strategy for defending the litigation. But if you hide critical facts like that from me, or you hide them from your attorney, you're putting your attorney in a terribly compromised position. It's going to ultimately backfire because everything comes out in the wash eventually, okay? The flip side of that is if you stole a bunch of documents, and I say stole because I mean come the fuck on, you stole a bunch of documents, okay? Well, I downloaded them to a flash drive. No, you fucking stole them, okay? Just be real about it, okay? Shorthand it, you stole the documents. I'm not going to sugarcoat it, okay? You want sugarcoating? Go to somebody else. I have too much fucking business to sugarcoat things for people, okay? So if your lawyer is telling you to keep that fact quiet or to slow play that bad fact, that is the wrong advice, period. I'll die on that hill, okay? If you stole a bunch of documents, you need to get out in front of it. You need to get out in front of it. You need to put it on the record, and you need to take the wind out of the other side's sails, okay? Let's go back to the case that I mentioned right at the top, the case called Mainsail, okay? So we had a preliminary injunction hearing, a multi-day preliminary injunction hearing in federal court in the Southern District of Florida. And so at the beginning of those proceedings, they had got an ex parte TRO, temporary restraining order, okay? And then we got involved, and then we briefed the preliminary injunction. We had a preliminary injunction here, okay? We get to the preliminary injunction here. And actually, this is one where I don't think we filed our brief yet. I don't think we had a chance to file our brief yet because it was urgent. There was a TRO, we got in, we had the hearing, and then I believe we filed our brief. So we go to the hearing, and the other side gets up, and they start doing their presentation where they're walking through all of the documents that they allege my folks, it was several people we were representing who had broken away from a bigger company, started their own venture. So they're walking through all the documents my folks allegedly took, okay? And so when it becomes, gets to be time for me to speak and to do my opening statement, I tell the court 100% transparently that my clients took a significant number of documents and that we admit that is a problem. That is potentially a problem from a breach of fiduciary duty standpoint, but none of those documents are trade secrets. We will fight on each and every document and prove that those documents did not contain confidential information or trade secrets. And then with respect to any breach of fiduciary duty claim, that could be remedied via money damages, but would not provide an adequate basis for injunctive relief. The judge was shocked. This is, mind you, this is the chief judge of the Southern District of Florida, or just recently was the chief judge, okay? Very, very, very sharp, very intelligent judge, been on the bench for a while. And so it basically turned into an appellate oral argument where me and the judge are going back and forth. At this point, opposing counsel is like, we're talking on another level here, okay? Me and the judge are talking about, one, she's shocked that I would be so forthcoming. She even said that she's never seen an attorney be so forthcoming about these sorts of facts. And I said, look, it's all going to come out in the wash, okay? They took it. That's a fact, right? That's a fact that I'm not going to run from, but I will fight on the trade secret issue. So let's talk about that. Let's talk about trade secrets, legitimate business interest, irreparable harm, damages, right? So then we're going back and forth. And ultimately, we defended that preliminary injunction hearing. We briefed the preliminary injunction, and we were able to beat most of the injunctive relief they were seeking. They got an injunction, but it was limited in scope, and it still allowed my clients to continue, right? They had to put up some Chinese walls. Some folks had to be cut off from certain parts of the business, but they were able to continue operating, growing, making revenue, fund the litigation. And down the road, we were able to resolve the case on what I think were very reasonable terms, given the allegations and given the potential exposure. So the point being, if there are bad facts, if you took a bunch of documents, right, in a trade secret case, what's the paradigmatic bad fact? You took a bunch of shit, okay? If that's the case, put it up front, okay? If you hide it, if you bury it, that will absolutely come back to fuck you. And if your lawyers are telling you to hide it or bury it, that's a problem. You need to get new counsel immediately, and you might have a legal malpractice claim against the lawyers who gave you that advice. Because number one, you have an obligation, right, of candor to the tribunal. But two, from a strategic standpoint, there's no possible way that if you took a bunch of documents, you can cover that fact up, okay? It's going to come out in the wash. You might as well front it and deal with it. Because a lot of times, like happened at that hearing, okay, the other side is often riding on the fact that you stole these documents, right? That is their big card. You stole these documents, and they're going to hammer that over and over and over again, right? They want to get you to deny it, so they can catch you red-handed with the proof and show that you're a liar, right? And all of that bodes very poorly for you as the case progresses, because these cases, right, like if you lie in a preliminary injunction hearing on the witness stand, you were so short-sighted. You were so short-sighted, because that is going to come back and fuck you. That's why you have to be fully transparent, not only because it's ethical, but also because strategically it is the smart play. You just out with the bad facts. You say, yup, we took those documents. It was wrong, but those documents are not a trade secret. Now, oftentimes, the typical big law strategy is to hedge on that point. They're not necessarily going to come out right and say they took documents, but they're also not going to lock themselves into saying, no, they didn't take any documents whatsoever. They'll find some way to hedge or to fudge it or to gloss over it, or they'll just outright deny it and say, we'll deal with it later. That is a bad strategy, okay? One thing you can even do, right, in the context of a preliminary injunction hearing, and this throws the other side off guard. We've done this before in many contexts. They'll be coming in hot, and I'll just interrupt and say, Your Honor, we're willing to stipulate that our clients took all of the 274 documents listed in Exhibit B. And so the plaintiff's big law lawyer is like, they were preparing to go through this list, document by document, have a fight over all the stuff we stole. And we're just like, no, my clients took it. We took those 274 documents that are on Exhibit B. We'll stipulate to that, but we deny their trade secrets. So let's focus on whether or not they're trade secrets. You actually move the framework there, right? So instead of fighting over, you stole the shit, did you steal the shit, how did you steal the shit, right? Bad. All of that's bad for you as the defendant, right? Bad, bad, bad. Makes you look like the bad actor. We're moving the dialogue, right? We're moving it from you stole a bunch of shit, you stole a bunch of shit, here's how you stole this, here's how you stole that, here's when you stole this, to are these documents trade secrets, okay? Strategy, okay? Strategy. Now, in connection with that, once you get out from under the, okay, we didn't take stuff, we stole it. You don't say we stole it, you say we took documents. Our client took certain documents, right? That's always what you say. Our client, yes, Your Honor, our client took certain documents. That's what you say. Our clients took certain documents, okay? You learn a little bit of law once you've done this for 20 years. Then you fight them document by document. Then you literally fight them document by document. And so one of the things I've seen, look, I just call it how it is, okay? Big law, for the most part, is unmitigated trash, okay? Are there good big law firms? Yeah, of course there are good big law firms, right? Where the roster overall is really impressive. Boyce, Schiller, and Flexner, the firm that I started my career at, that's a good example, okay? And I've hired Boyce Schiller to be my co-counsel on certain really big cases. Like if we had like a trial court proceeding and then an appellate court proceeding, I've brought them in because they are the firm, the big firm that I personally am able to vouch for. I've worked with a lot of those folks. I've worked with those folks for, 15 plus years. I know their capabilities. I know that they are super responsible. They're super diligent. So I have brought them in on some of these cases. But I was talking about fighting. I lost my train of thought. I'm sorry, okay? But I know where I was now. I was talking about document by document. Here's how big law comes into it, okay? Consistent with what I was saying before, right? Where big law comes in and they want to spend an hour or two going through the documents and saying, did you steal this? Did you download this? When did you download this? Is this, what is this ISP or what is this address on this? Or what is this file stamp on this? And this is yours and you emailed this to yourself, right? They want to spend 2 hours going over the you stole this part of the case, okay? And then if you just stipulate and you move on and you start fighting on the trade secrets, they're not prepared for this, right? They're not prepared for anything that is the least bit southpaw or unorthodox, okay? And they're not capable of thinking on their feet. So when you get into document by document, and I've seen this happen in many, many cases, oftentimes if it's just whatever generic big law attorney, they are not going to be prepared to fight with you on the trade secret nature of all those 274 documents, right? Isn't that a bit strange how they've got the, file stamp or, whatever technical back end audit trail data they have to show that you stole this stuff, right? But that's so mechanical, okay? If you downloaded it to a flash drive, they just get the data, right? And it shows that 274 files were moved over to a flash drive. They're gonna fixate on that on a document by document basis and think that like that's going to be overwhelming proof that you are a baddie and should be enjoined. But on the flip side, when it comes to going through the actual substance of those 274 documents, just use 274 for an example, right? We'll just stick in that wheelhouse. When it comes to the actual substance of those 274 documents, they are not prepared to get down, right? And it just goes to show you, like, so much of big law, it's just a big fucking law firm with a bunch of lawyers and probably a little fountain in their office, okay? And that's what's fooling so many of you. I get calls all the time from people who are like, "Oh my God, can JP review our case? We've been in litigation for a year and a half. We paid $4 or $5 million, and it's more coming every day. And we're represented by this big firm, and I don't think they have any strategy. And they're always playing defense, and they're always reacting to stuff, and they're never like driving the case. And I don't think they know what they're doing." Well, they probably don't fucking know what they're doing. They probably don't know what they're doing. Okay, like this shit's documented. This is documented. Okay, how many big firms have I cooked in the course of my career? Okay, they're just big. They're just big, and they typically are not prepared to get down on a document by document basis with respect to what's the substance of the document and is it a trade secret, right? All of this makes 100% perfect sense because the printout of like a document audit trail, that's just mechanical. They can just get a copy of that and read through it and say, this shows you stole this shows you stole that. It's cookie cutter. It doesn't require any thought. Going document by document through 274 documents to prove whether or not something is a trade secret, now that takes some serious intellectual work, okay, of the type that these folks aren't doing. The other piece of this that I often see is the lawyers who are on the plaintiff side in non-compete and trade secret case. I'm gonna keep this about trade secrets, but I see it in the non-compete space as well. They have fuck all zero understanding of the relevant market. They have no understanding of the relevant business, the industry, how it works, if it's technology, how the technology works, what the technology does, how customers are acquired, how relationships work, how pricing works. They don't understand any of this shit. They just start with, you stole these things from our client and these things are trade secrets, and you see where it says confidential. Okay? This is how these cats have been litigating these cases for 30 years. And unfortunately, this is going to lead me to another topic, okay? Unfortunately, that's been effective in certain parts of the country. And I'll tell you where the sort of standard folksy, old-timey, good old boy, Joe Fuckstick, big law, attorney at law routine in these cases, I'll tell you where that's effective. That is typically effective in conservative, so-called conservative areas. The South, the conservative Midwest, it's effective there because you get all of these judges who are these, they view themselves as the moral authority, right? So rather than thinking my job is to apply the law, okay? The law says this defines a trade secret. Here's the elements. Did the plaintiff meet the elements? They don't view it like that. They view themselves as the moral authority, and they view themselves as the one who is going to punish the bad actor. Right? You see this a lot in non-compete and trade secret cases where, especially non-compete cases, okay, where judges want to punish the person they think is the bad actor rather than being neutral and simply applying the law. And so if you stole a bunch of documents, that is going to potentially make you, in the eyes of certain judges, the bad actor. They're going to have an axe to grind. They're going to want to punish you. It's not supposed to work like that, folks. That's judicial activism. It's blatant judicial activism, but that is very common, especially in the South and the conservative Midwest. So yes, if you took a bunch of documents, there's already from the jump certain obstacles you're going to have to beat back, but you do yourself no service by hiding that fact, because especially if you have one of these very conservative, sanctimonious, moralizing types who view themselves as the moral police and the moral authority, if you don't come up front with the fact that you took the documents and they find out later in the case, they are going to tag you, and the consequences could be catastrophic. Because often in cases like this, yes, we're talking about damages in some instances, but in a lot of other instances, we're talking about injunctive relief, right? Like these are cases where my clients have started a new venture or joined another company, and there's 20, 25, 30, 40, sometimes $50 million at issue in terms of the market, right? In terms of revenue that they can go out and get. in a short window of time, and oftentimes it's an industry that's very high margin. So, we've had situations where our client stands to make $40 million in the course of 12 to 18 months if they can stay operational. And of that, profit, the margin is at least 70%. So these are incredibly high margin ventures where the opportunity is there to make tens of millions of dollars, provided they don't get enjoined. And so, yes, you're fighting on damages, but an equally significant, if not bigger, part of the equation is the threat of injunctive relief. And so what you want to do in the context where you have taken documents or you've stolen documents, you've misappropriated documents, you front it and you fight on whether or not the documents are a trade secret, because you're trying to get, obviously you want to get the injunction defeated across the board. But if you can't get the injunction defeated across the board, you're trying to create an opportunity there where the judge can enjoin you or enjoin your clients, right, in a more narrow fashion, right? You're fighting to beat the injunction outright, or if you can't do that, give the judge the opportunity, give them the pathway there to enjoin you on a more limited basis so that you can remain operational and keep growing the business and keep making money and keep funding the litigation, so you can fight the litigation out and then ultimately collapse the other side. Because if they don't get, in many of these cases, if they don't beat you at the injunction stage, they will have significant problems proving their damages. That's why the injunction part of these cases is often 70% of the battle. Jonathan Pollard, JP, thanks for watching. Have a good day.